So my name is Rob Harrison, and as Pam said, I'm a lawyer, and I specialize in estate planning law. Estate planning law, as I'm sure you know, is things like wills and trusts and all that business, and I can answer questions about that stuff. But what I thought I might talk about for just a few minutes is one particular area of estate planning, and that's planning for incapacity using powers of attorney and advanced healthcare directives. So the situation we're addressing is where a patient reaches the stage where they can no longer manage their affairs, and as a matter of law, they don't have legal capacity. They can't understand what they're doing. They can't sign checks. They can't sign contracts. They cannot direct their own care. How do you handle that? How do you plan for that? So that's what I'm going to focus on. When I think of these things, I try to start at the beginning. And the beginning for me is to say, well, what if I haven't done any planning? And I have reached the stage where I no longer have capacity to act for myself. What happens? How do my affairs get handled? Well, the answer is that in California, the answer is something called a conservatorship. A conservatorship is a court proceeding that appoints somebody to manage the affairs of another person. The person appointed is called a conservator. The person for whom the appointment is made is called a conservatee. So those are the terms of art. Conservator is appointed to care for the conservatee. There's a couple other terms. One is called a conservatorship of the person. Something else called a conservatorship of the estate. The appointment can be either a conservator of the person or the conservator of the estate, or both of those things. The conservator of the person is in charge of the person's, physical care and medical decisions and so forth, personal decisions. The conservator of the estate is in charge of the person's money, finance. And in most cases, both are appointed, but it could be that one or the other only is appointed. As I said, it's a legal proceeding. It occurs in the court of the county where the conservatee lives. There is a petition filed generally by the conservator to be appointed. There's a bunch of procedural issues to be addressed. Notice is sent to the conservatee, notice is sent to relatives. There's a court hearing where a judge determines that the person does lack capacity and appoints the conservator to act for them. Once the conservator is appointed, they have the magic document, their appointment as conservator, and that allows them to go out in the world, take control of the conservatee's assets, manage those assets for the benefit of the conservatee, and make decisions, if they're conservator of the estate, of the person, make decisions for that conservatee's medical care. Most everything the conservator does is subject to the supervision of the court. And there are as I said, a lot of procedures, a lot of protocols involved to protect the conservatee and to keep track of the conservator. For example, the conservator has to file a list of the assets, an inventory of assets, have those valued by a court-appointed appraiser. There's typically a court investigator, an employee of the court who comes and visits the conservatee and makes sure that everything is running smoothly. At least a year after the conservator is appointed, they have to come back to the court, give a full financial accounting of everything they've done, and give a report on what they've done. And then every 2 years thereafter, at least, they have to do that kind of accounting. So that's, in a nutshell, what a conservatorship is. And as I said, if you don't do any planning, that's the mechanism for managing assets of an incapacitated person. Conservatorships have a reputation, and deservedly so, for being costly, cumbersome, awkward, difficult, and all those things are true. As I said, it's a court proceeding, so there's lots of forms to be filed and documents to be shuffled back and forth. Things happen slowly. It takes a month to get an appointment of a conservator. Because of all these procedural things, there are typically lawyers involved. Typically, a lawyer represents the conservator, and sometimes a different lawyer represents the conservatee. Lawyers like to get paid, so these things tend to get expensive. There's also court filing fees, and you pay for this court investigator, and you pay for this appraiser. So it's the cost and the time delays that tend to make people kind of not want to do this. The other thing about a conservatorship is it's a court proceeding. It's a public proceeding. And if anybody cared, they could go pull the file and say, oh yes, this person is subject to a conservatorship. And some people are uncomfortable with that kind of public disclosure of what's going on. So if given the choice, most people might say, I'd rather that if I reach that stage, my affairs not be handled that way. Well, the answer is you can do some planning that typically can avoid a conservatorship. And the planning involved is to sign, while you have capacity, before you've reached the state of incapacity, to sign a power of attorney and to sign an advanced health care directive. So I'm going to focus on those two documents for just a couple of minutes. A power of attorney is a document that appoints somebody else to manage your affairs. So it's in writing, it has to be in writing. The person who signs the document, who gives the power, is called the principal, and it's like school principal, P-A-L, school principal, and the person who gets the power is called the agent. So we've got a principal and an agent acting under a power of attorney. And we're talking again about a power of attorney for management of business and financial affairs. The power of attorney must be, as I say, must be in writing, must be dated, must be signed, generally needs to be notarized. So there's some formalities that need to go with it to make it effective. There's no particular form of power of attorney that works. There's lots of different powers of attorney. I brought one example of a power of attorney. I think there's copies over on the table, which is the uniform statutory power of attorney. This is one form of power of attorney. There are other forms. Lawyers, people like me, to do what I do, we write powers of attorney and tailor them to our clients. There's lots of forms. I used to say you go to a stationery store and get one, but I don't think there's stationery stores anymore. I guess there's Staples. But the internet, you can Google power of attorney form and they'll come up. And they're all generally a little bit different, but they all kind of mean the same thing. Most financial institutions like banks and brokerages have their own forms of power of attorney. And it's a good idea if someone has a particular account that they want to have managed to use that bank's or brokerage's account form in addition to signing a regular form power of attorney. And a power of attorney executed in another state is also valid in California as long as it's executed in accordance with the law of the state where it was signed. Unless the power of attorney states that it's for a limited period of time, once it's signed, it stays in effect, so it can last for many years. However, the principal can revoke the power of attorney at any time or can amend it, as long as the principal has capacity, they retain the power to revoke the power of attorney. One important point is that the power of attorney is automatically revoked if the principal dies. See, I've had clients call me, or potential clients call me and say, my father passed away, but has no problems. I got his power of attorney. I can deal with all his property. And the answer is no, it doesn't work. Once the principal has died, the power of attorney is no longer effective. There's a crazy rule of the law that says that the power of attorney is automatically revoked when the principal becomes incapacitated. And that's not so good because, right, that's when we want it, unless it's a so-called durable power of attorney. So there's an important term of art called a durable power of attorney. A durable power of attorney is one that by its terms remains effective after the incapacity of the principal. So those are kind of magic words. And in this context where we're planning for incapacity, we want a durable power of attorney. This form that I showed you, the statutory form, is a durable power of attorney. So that's an important thing to look for if someone is setting up a power of attorney. In most cases, a power of attorney is effective when it's signed. So immediately upon signing, the agent has the power to act for the principal. Now, just because the agent has the power, that doesn't mean that the principal can, as long as the principal has capacity, the principal can also act. So let's say I want to appoint my daughter as my agent. So I sign a power of attorney naming her my agent. She can sign in my accounts, all those things. I can still do it as long as I have capacity. The fact that I've signed the power of attorney doesn't disable me from doing it. But she now has my power of attorney, and I sign it today. She can go out tomorrow and sign my checks and sell my house and borrow in my name and all those things that agents can do. Some people are not comfortable with doing that. So the solution, there's something called a springing power of attorney. Springing, it springs into life at some future event. And typically the future event is, if I become incapacitated, then at that point, this power of attorney shall be effective. So that's an alternative to consider if someone's doing planning, whether they want a springing power of attorney. Most powers of attorney are written as general powers of attorney. You see that term a lot, a general power of attorney. That means that the agent has power to do basically anything that the principal could do, could sign contract, any kind of thing the principal could do. You'll often see in some contexts a more specific document, a special power of attorney, which just authorizes the agent to do some particular thing, just sign checks or just deal with a particular piece of property. So again, it's a planning issue as to which of those is appropriate. Under the law, there are certain powers that are considered so sensitive or so dramatic that they have to be stated in the power of attorney in order for the agent to have that power. Those include things like the power to make gifts on behalf of the principal, the power to amend the principal's trust, or to change beneficiaries under a retirement plan, or the powers to make loans to the agent or gifts to the agent. Those would have to be specified. The holder of a power of attorney cannot make a will for the principal. That's one power that the agent does not have. So a power of attorney, the beauty of it is that unlike the conservatorship, it's pretty simple. It's signing a document. And once it's needed, the agent just sort of starts acting, starts doing the things that they need to do. The agent acts without any kind of court supervision. They just go ahead and do the things that they need to do. So that's giving your agent a lot of power. It is a power of attorney. So you be careful in choosing that agent. So as I said, that's sort of the disadvantage of the power of attorney. There's not this court supervision of what the agent can do. Now, if there's a problem, the courts are available. So a proceeding can be filed in the probate court to, with respect to a power of attorney, to determine whether the power of attorney is effective, to require the agent to account if he's done something wrong, or any other issues. So the court is available, but typically these things act completely outside the court system. The person designated as the agent has no obligation to act. So if you're designated as an agent, you can say, well, I'm not interested in doing this. You have no obligation to act. Once you act, however, once you take some action on behalf of the principal, you have a fiduciary duty, and you're obligated to act in the best interest of the principal. And as I said, you can be held to account to the court if you violate that duty. There's a common estate planning document called a living trust. And if many of you have been through this process, you probably thought about having one living trust. And just talk a minute about that. Typically, the reason people do living trusts, it's really an alternative to a will, and people do a living trust to avoid probate. So that's kind of the issue behind doing a living trust. However, a living trust also provides some management of assets in the event of incapacity. If I set up a living trust and I name, say, my daughter as my successor agent, I'm the agent, my daughter's the successor agent, typically I'm thinking when I die, she'll be the trustee of the trust. Well, if I become incapacitated during my life, she becomes the agent then, the trustee then, and can manage those assets inside the trust. So again, a living trust does have this other benefit of allowing some management during incapacity. When people like me do estate plans for people and we do a living trust, we typically also do a power of attorney. And I get this question all the time, why do I need a power of attorney? I have a living trust. Well, the answer is the living trust only applies to assets that are in the trust. And there may well be assets outside the trust. Oftentimes there's a bank account outside the trust, or cars or something like that. Also, there are some actions that just by their nature are not living trust things, like the power to sign a tax return, or to claim a tax refund, or the power to file a lawsuit, or defend a lawsuit, or make a claim. So typically, an estate plan includes a power of attorney in addition to the living trust. So power of attorney, as I said, we're talking here are to handle financial and business issues in the event of incapacity. The complementary but different document is the Advanced Healthcare Directive. The Advanced Healthcare Directive is the current term used in California for the document to appoint a healthcare proxy or healthcare agent. The same terms are used as in the power of attorney, principal and agent. So by a Advanced Healthcare Directive, the principal can appoint an agent to make healthcare decisions. This document used to be called a durable power of attorney for healthcare prior to year 2000, so you sometimes still see that term. Now it's called an Advanced Healthcare Directive. By the way, if one was signed prior to 2000 as a durable power of attorney for healthcare, it's still valid. But the terminology has changed, and the current forms are called Advanced Healthcare Directives. Again, there's no particular form of Advanced Healthcare Directive, and there are a variety of different forms you'll see. People like me, lawyers like me, we write Advanced Healthcare Directives for our clients. But there are a variety of other forms out there. One form that you see a lot is this one, which is published by the California Medical Association. And there are some copies up there if you're interested in looking at this. And this is sort of a do-it-yourself thing. It's really designed for somebody to do on their own. And it explains what you have to do to make the document valid and what the effect of all this is. So this is one form. A lot of HMOs and hospitals have their own forms of Advanced Healthcare Directives. I know Kaiser has one, and most of the hospitals have their own forms. They're all fine, by the way. I tell people, sign away. They're all fine as far as I'm concerned. Unless specified otherwise in the document, the Advanced Healthcare Directive becomes effective only if the principal cannot make decisions for themselves. So I talked about this concept of the springing power, and that applies generally in the area of Advanced Healthcare Directives. And it's the principal's treating physician who determines, do they have the capacity to make decisions, and if they do not, then they look to the agent named in the Advanced Healthcare Directive to make those decisions. Again, there's some formalities that need to be required. The Advanced Healthcare Directive needs to be in writing. It needs to be signed by the principal. It needs to be either notarized or witnessed. The witness, if you've ever seen a will witness, it's like that. But most people get them notarized. There's some additional requirements. If the person is a patient in a skilled nursing facility, the ombudsman has to act as a witness. So there's some formalities, which, by the way, which are all explained in this yellow book that I just showed you. But just be aware that those are those apply to Advanced Healthcare Directives. And like the power of attorney, the Advanced Healthcare Directive, once it's signed, it remains valid indefinitely, again, unless it's somehow limited in time. Once the Advanced Healthcare Directive is signed, and once it takes effect because the principal has become incapacitated, the agent has the power to make all healthcare decisions. Whatever decisions that the principal could have made, the agent now has the power and capacity to do so. That includes, choice of healthcare providers and course of treatment and medical testing and all that business that you could decide for yourself. Once the Advanced Healthcare Directive has become effective, the agent can make those on behalf of the principal. What most people think of when we're talking about this in my office, they think about this use and withdrawal of life support, kind of end-of-life decision. And yes, it's the Advanced Healthcare Directive, the holder of the Advanced Healthcare Directive, the agent there, who makes the decision for the principal if the principal cannot make them him or herself. Oftentimes, people in doing their Advanced Healthcare Directive, they include directions to the agent. That is, what would you like to happen if this situation arose? For example, if you were faced with a decision regarding use and withdrawal of life support, what would you want the agent to consider? And most of the forms, including this yellow form, has kind of a discussion of an option. You can check a box, or you can always add other things. So the Advanced Healthcare Directive will often include directions from the principal as to how to handle particular situations. Following the death of the principal, the holder of the Advanced Healthcare Directive has the authority over the disposition of the remains. That means funeral instructions, cremation, so forth. So it's the Advanced Healthcare Directive that becomes the important document in carrying out funeral instructions. And so it's important that whoever holds the Advanced Healthcare Directive knows what you want, one way or the other, right? Because they're the ones who have the power to do it. The Advanced Healthcare Directive agent also has the power over autopsies, over anatomical gifts. And again, those are all often things that are specified in the document itself. The principal can express a preference on how the agent should carry out those duties. So just to circle back to where I started, these are the Advanced Healthcare Directive and the durable power of attorney are planning tools. They're things that you have to do, while you have capacity. You can't wait and do these later. So I would urge everyone to consider these things, and if appropriate, take action on them. So that's all I have to cover in my section. Daniel, I think you're up.
Thank you. I learned quite a few things there. When it comes to accessing health coverage, we know that there's public and private, and most people have a lot of misconceptions about how the two systems work. I'm going to briefly go over some of the issues when it comes to accessing public coverage. Many of you have heard about the Medi-Cal system. That's California's version of Medicaid. That's a program that is currently designed for people that are low income with low resources. My focus in the area that I work in is disability-based benefits. So I work, like with programs with SSI, SSDI, long-term, short-term disability, and then access to health coverage, whether it be public or private. The thing about Medi-Cal is that when it comes to accessing it before you have any kind of long-term care needs, there are different what are called eligibility categories. There's different ways that you can qualify. Most of them are pretty limiting because they really aren't designed to cover everybody. It's not uncommon that I find people dropping health insurance to go onto the system, and then they find out that they have to do what's called spending down of a lot of their resources. In many cases, for an individual, you can have $2,000 in the bank, $3,000 for a couple. It's because when the law was written in the 70s that you could buy a Toyota Corolla cash for that, and that was a down payment on a halfway decent home. But the laws haven't changed, and they, over the years have been fighting and fighting to take away more and more from California's Medi-Cal program, which in other states it's called Medicaid. It's federally funded, and then the states specifically decide, how they're going to do their particular program. In California, what I find that most individuals are going to qualify for if they're going into Medi-Cal in a non-long-term care situation is either age, blind, and disabled Medi-Cal that allows you income of about $1,203 a month. And that would be your total income, even when we're talking about unearned income, like from disability. If there's earned income, they look at half of that income after a few deductions. If your income is above that, it's all or nothing. You don't qualify for Medi-Cal at no cost. You'll go into what's called the share of cost system. And that's where they give you $620 to live on. And everything above that becomes your monthly share of cost. So it really isn't a very cost-effective program, although a lot of people find themselves in that program. Now, there is a way that I have found for a lot of individuals who have found themselves stuck with Medi-Cal as a form of health coverage is the California Working Disabled Program. And the beauty of this little magic bullet, as other people have termed it, is that it's a way to be in the Medi-Cal program and have a job. I have people who take care of pets, and I have one person who recycles aluminum cans, and somebody who makes $20 a month doing internet searches for parents. But if you have a job, they're going to disregard any of your disability income. And they're only going to look at what income you have from employment, and then you pay a small premium for it. Although you're still limited to $2,000 in the bank, one house, one car, but they will disregard any resources that are retirement products like an IRA, 401k, 403b. So that's kind of the little mini version of normally I spend, when I do trainings on benefits, I spend anywhere from 1 to 3 hours talking about these types of Medi-Cal, just to give you kind of a sense of what that is. Another public program is Medicare. Medicare came about quite a few years ago, and because it came about via different laws, it comes in parts, and many of you have heard of Medicare Part A and Part B. Well, it comes in those two different pieces because it was written by two different laws, over two different periods of time. And Part B is optional, but if you decide not to take it, you'll be penalized. So the word optional, be careful whenever you look at one of these programs and you see the word optional. You want to make sure that you are exercising your options in a way that you're not going to pay the price sometime later down the road. So Medicare, for people who are under age 65 and are dealing with disability, 18 to 65, they would get it being eligible for Social Security disability insurance. Social Security has two programs for people with disability, one that is based on need and one that is based on your contributions. The one that is based on needs is one of the ways you can get Medi-Cal. But again, it's very limiting who it covers. Where Social Security disability insurance, even Bill Gates could get Social Security disability insurance. It's based on your retirement money. In 1956, they said, we're going to allow people who are disabled to access their retirement money early. And then they built in a provision that says you can also get Medicare after being on 29 months. There are exceptions for certain disabilities. Medicare, the problem or the challenge with Medicare, it's not really complete coverage, and the copays and deductibles are very, very high. So what people have to do is they have to supplement, and they can get, there's a whole host of ways you supplement. You can have what's called a Medicare supplement, or you can enroll in a Medicare Advantage plan. And there's a couple of different, and sometimes people use Medi-Cal as a way to supplement. But having Medicare standalone is very, very dangerous if you have hospital expenses. It can be very, very high. A hospitalization with somebody with Medicare by itself, I've seen it be in the thousands of dollars. So you really want to be able to supplement that coverage. Also Medicare, that's a strange sound. Oh, it does? Oh, okay. It sounds very futuristic. It's like one of those movies. So Medicare also started covering prescription drugs in a very, well, basically, I'll be honest with you, for political reasons, they started a drug plan, and they did such a poor job with creating that drug plan. It has huge deductibles and copays, and it has what's called a donut hole, which is a coverage gap. And then to be able to meet the coverage gap, you have to, have low income to do, one of the subsidy programs. So it was kind of a fiasco in my personal opinion. When it was created, that is one of the things that the new health care bill, hopefully it stays in place, will be addressing, and it's one of the few things that it addresses in the world of Medicare. It's going to be closing, and it has been closing that donut hole. So then, there's actually a real prescription benefit that's available, because prior to that, there were limited prescription coverage, that was available, but they put this in a way that didn't work real well. Okay, I was going to set a timer for myself, and I forgot to. Anyway, let's talk about private benefits. When it comes to private benefits, a lot of people don't realize that if you have a pre-existing condition, currently getting into the the world of insurance is pretty much impossible. We used to have the major risk medical insurance pool, which was for people, Mr. MIP is what it was commonly referred to. Very highly used by the HIV/AIDS community for many years, and the breast cancer community were two different communities that were very involved in utilizing that program. And that typically was set up for people who tried to get health insurance, were denied, and then the state subsidized and then allowed you onto a plan. And then when the health care bill passed, they came up with a temporary little way to insure people until 2014. So if you have a pre-existing condition, the only way that you're going to get health coverage is through an employer until next year. And that's the way that you can enroll as far as without having to provide evidence of insurability. And even with a pre-existing condition, if you get into an HMO, you're covered immediately. And this is specific to California. For a PPO, which is a preferred provider organization, it's going to be 6 months. And then the other kind of coverage that you need to be aware of is a self-insured trusts or self-funded trusts. That's where they have like a pool of money that an employer, a large employer, they actually take some kind of fund and then they actually use some of that interest to pay out claims. And that's a self-funded trust. Those have 12 months, so they don't have to cover pre-existing condition. Now, because we're at the end of the year, I don't have to go into the law that President Clinton passed, which is how you use previous coverage to wipe out the pre-existing going into a new plan, because starting next year, everything going well, there will no longer be pre-existing for individuals accessing health coverage, which is going to be terrific. In other words, everybody can go out into the marketplace. You want to buy a health plan, you can. If your income is low, there are either freeways or not freeways like driving freeways, but there's free access. They're expanding the Medi-Cal program. Medi-Cal is getting expanded to individuals that are 138% of the federal poverty level. That's going to be income as high as $1,321. Now, for some of you, that doesn't sound like a lot, but you'd be surprised. I mean, individuals at that high of an income didn't qualify for Medi-Cal before. And the real nice part about this is that they're not looking at assets. So you can have $200,000 in some kind of an account and not have to do a spend down and get rid of that money to qualify for Medi-Cal. And it's real important. Like I had this one client come to me who was very financially savvy. He had quite a bit of money and quite a few pieces of property, but he didn't have health insurance. And he was diagnosed with a serious medical condition and practically lost everything because he didn't have health insurance. So, it's really important that people have health insurance as a part of what you're planning. People in this country focus more on automobile insurance because they have to than they do on health insurance. And I think that we're going to find out the have to part of health insurance once we get over the have to part. The benefit is that, for the most part, the coverages that are being offered are better than what's been out there. The plan rates are better than what's been out there. I'll use myself as an example. I have a pre-existing condition, and I was on a COBRA plan because I was on my partner's coverage, and in California, COBRA lasts for up to 36 months. It's the 18 months that's provided by the federal government. In California, we're offered an additional 18 months. That part's not changing. But at the end of that, because I have a pre-existing, I have no coverage. So I had to go on what was called a Hipaa Plan, which is what Clinton created a long time ago when he tried to deal with the issue of the fact that we don't have an equitable system to cover people with pre-existings. Well, my premium went from $800 a month to $1,950 a month. Okay? And that's what's available to people right now. Next year, with the new health care bill, my premium is going to be $500 a month. And I have a host of plans. I'm going to be selecting, because the new coverages, they're platinum, gold, silver, bronze. I don't know where they came up with these systems, They do these focus groups, and they come up with some of the, in my opinion, strangest things. But they decided they're going to come up with names that are metals. I was wanting to know what the tin coverage was, but I was told they don't have it. But basically, if you know your metals, bronze, silver, gold, and platinum, I'm going for the platinum coverage, and I'm paying $500 and change. And the platinum coverage is going to reduce my copays considerably. So it's the new health care bill. The beauty of it is that people who are below 138% of the federal poverty level, they're going to have access to Medi-Cal, commonly referred to as Medicaid in other states. People with income between 200 and 400% of the federal poverty level, that's $15,971 to $45,960. They're going to have subsidies that are going to actually subsidize the cost of the health insurance. Now, I know a lot of you have heard on the news, I'm losing my health insurance. Well, if you look at the health plans that people are losing, they're losing them because they're substandard plans. In other words, one of the examples of somebody who is losing their health, and I'm not trying to be political here, I'm trying to be factual. One of the people that was talking about losing their health plan, it was health coverage that didn't have hospitalization. Now you tell me the value of a health plan that doesn't have hospitalization. You know, that's like automobile coverage that's going to cover you only if you get a scratch, but if you have an actual accident, you know, sorry, you have no coverage. And the person who was talking was low enough income to where with the subsidy, they would have been paying $10 a month more and had hospitalization. Now, I'm not saying that the new system is perfect, and I can tell you one thing, the website is a mess. The California version of the website, excellent. The first 2 months, few problems. Right now, it runs just fine. So what it is that there's a national, for this new healthcare thing, and I don't work for them, but there's a national website for the states that have chosen not to create their own individual websites. California, Hawaii, there's other states that are more progressive. They actually have created, like ours is called Covered California. And it works really well. And it'll actually calculate. There's a few problems with it. It's not perfect because you see everybody wants to take and look at it. It's like you want to look at a car and you want to see the slip on the outside before you go into the dealership and start talking money. Well, unfortunately, with their website, you have to give them your information before you can actually start looking at the prices. But your information, you know, is safe. And once you start looking at prices, you can see that it's pretty affordable. And then if you qualify for a subsidy, it'll tell you right then and there. It actually does the calculating for you. I highly recommend it. It's relatively easy to work with. Now, as far as long-term care options, it's not an easy issue. If your employer offers long-term care, take it, because it's the least expensive way that you're going to get long-term care. Long-term care, you've got to be in good health. The bill had a provision for long-term care, and one of the pieces that was chipped away at was the long-term care coverage, which I was so excited about, because really the only long-term care we have, Medi-Cal. And Medi-Cal long-term care, you need to see an elder care attorney who specializes in how to deal with all of the nuances that are around that if you have any resources whatsoever, and also how to protect anything that you have, such as a house, so that your children can have it. There are ways to deal with it, but it is very intrusive, the long-term care system through Medi-Cal. It's very, very intrusive. And, you know, if there's any way that you can access long-term care coverage through an employer, I would highly recommend it, or if you're in good health. It's a lot of money, but if you ever need it, it will really serve you. It'll really serve you. I was so looking forward to finally having other long-term care options, but it was taken away. And there may be pieces of the law that from now until when it actually is finally implemented that will take place. I don't know. But what I've shared with you is what was, what is, and some of the what will be. So that's my little spiel on access to health coverage.
Thank you. So I think what you just said, and why, of course, I learned so much today. But what you just said actually fits into what I'm going to talk about really well. So I'm going to be focusing on where's the money. Well, what are we going to use to pay for the home care services, right? And before I get into that, I kind of want to explain a few concepts. Like you hear this all the time, but I see so much confusion when we provide care for our clients. So the first one is when we talk about home care services, and we have to separate the non-medical home care services versus the skilled nursing or the medical-based home care services. So for the when we talk about non-medical home care services, we're talking about anything related to ADLs, or activities of daily living. And this is restricted for anything that is not intravenous. There's no feeding tubes. There are no feeding tubes. There are no injections. There are no infusion services. So those are the non-medical home care services. What does it cover? It covers companionship care, which includes being a simple companion, play games and provide mental stimulations through games, activities together, crafts, baking cookies and prepare meals. Transportation is part of that. What else? Like handling finances, sorting out the paperwork and stuff like that. And also there's personal care service. toileting assistance, bathing assistance, transferring from bed to wheelchair, from wheelchair to toilet to bathtub, that kind of services, walking, turning clients in bed, oral hygiene services. So those kind of bowel care, right, and incontinence support. So those are included in the personal care services. So those are the things the non-medical home care services cover. And then when we talk about the skilled nursing services, would be injections and interpreting the vital signs by, say, poking your fingers and checking on the blood sugar level for diabetes clients. So those are the skilled nursing services. When we separate that, we can talk about what pays what. The common things when you think about home care services when it comes to an elderly, the misconception is Medicare will cover it, which is almost completely wrong because Medicare does not cover it, almost not entirely, right? Nothing. And I can't really say nothing in a way that some of that will be covered. So we'll specifically talk about the difference, what's covered, what's not covered, right? First, when we think about age requirements, so for Medicare to cover anything, and you have to be at least 65-year-old. And you must be homebound. Like even leaving the home is a taxing effort. And someone's gonna do the evaluation and you have to be, we used to say you have to be bedbound, but these days you have to be homebound. And the doctor's order is required, and the doctor must see the patient face to face, and they have to do evaluations for this kind of services to be covered. And it's only for skilled nursing or therapy services, right? Infusions, skilled nursing, injections, feeding tubes, stuff like that. And there's a weekly service limit, and usually it's 3 to 5 visits per week. And what about the length of the visit? And it's about 45 minutes. Well, it's 15 minutes incrementals, right? And most likely it's less than an hour per visit. Sometimes people call that a bathing visit. And the home health aides come in, and then they bathe the clients, 45 minutes, and then they go. And that's pretty much about it. What about the income limit? There is no requirement, but the client must have paid into the Medicare benefit before, and that's required. And the length of the service coverage, normally that's about 60 days. And then after 60 days, it can be renewed, but the doctor has to review it, see the patient face to face and do an entirely new authorization for that to be continued. And what about the source of the pay is from Medicare, right? That's already paid into the funding support. And the services that are not provided, and that's the homemaking services, and also, those are the services I mentioned earlier, like the companionship services, or sometimes people call that homemaker services, or the personal care services, the other kind of personal care services. They're not included. Running errands and transportations are definitely not included. So that's specifically about Medicare home health services. Medicaid or Medi-Cal services are talked about. So I'm going to take that from a different angle. For the home care agencies, like say what we do, right? And my company is called Starlight Caregivers, and we're based in Palo Alto. And what we do is we're called full service agencies. And what I want to give you a little bit background of that. So when you or your loved ones need home care services, there are 3 ways you can find the caregivers. In addition to you yourself or family members being the primary caregivers themselves, right? There are 3 ways to find a professional caregiver. And the first one is you hire a full service agency to provide that kind of services for you or your loved ones. And the full service agencies, they do everything. And the caregivers are their employees. They're background checked, they're fingerprinted, they're trained And most likely, there are certified nursing assistants, certified home health aides, or sometimes there are nurses, even though they do private duty home care services. It could be LVNs, licensed vocational nurses, LPNs, licensed practical nurses, and they could be sometimes an RN, right, retired RN in any cases. So they have the medical background, or they could be a medical assistant on the other hand as well. They have some kind of license. And they're highly trained. They're trained to do different kind of services, not only the very general home care services, but also specialized in, say, Alzheimer's dementia care, post-surgery operation care, to care for someone that just had a hip replacement or knee replacement, right? They're specialized in that. And they're also specialized in, for example, hospice care. And they're skilled, and they have the right personality to care for someone that is dying. So that's the qualifications they have. And the care agencies, the full service agencies, they pay for their employees, so they have to pay for their benefits, they have to pay for their taxes, also pay for their workman's comp insurance in case they're injured on the client's property. And the agencies, they have to take care of that, right? Of course, I mentioned they pay for the taxes and also pay for the training for them, continued education credits. So those are covered by the full service agency, and they're also bonded. And if they belong to certain organizations that, for example, we belong to CASA, California Association for Home Care and Hospice Services. They require all the employees or the caregivers are bonded. So if there's theft happening at the client's home, that's covered as well. And so that's just some examples and you get from full service agencies. So the families, they don't worry about anything. Anything happens, it's covered by the agency. And you always have someone that's qualified coming into your home to care for your loved ones. And then on the other hand, if they get injured, then there's insurance already to support them with their injury. The second source is you can hire a registry. It is also an agency to provide caregivers to you. But then once they're kind of like a matchmaker, right? You call them and they send someone to your home. You can interview this person as a caregiver. Once you decide you're going to go with this caregiver, then you become the employer of the person. And it's a 1099 relationship. They're independent contractors. You become the employer, so in turn, you're responsible for the taxes. You're responsible to provide 1099 at the end of the year. And you're responsible if this person is injured on your property. And you're responsible to check on the backgrounds of this person. Like, for example, the full service agencies, like what we do is we check on the federal, when it comes to background checks, we do the federal database, FBI database. We do all 48 counties in California. If they come from outside of the states, and we do all states in the United States. And we also check on the sexual crime database, the DMV record, and just different databases, right? We try as many as we can. But then if you are the employer yourself, then you do those background checks should you decide to do that. And by the way, we also fingerprint them. So you're responsible because you're the employer. And most people don't realize that, but that's something you should be aware of. The third way to go for it, a lot of families do, which is most economical way to do it, is a private hire. You hire someone, you take the effort, you can go on the Craigslist and you can post an ad on newspaper and you look for a caregiver. You interview the caregiver and you check on the backgrounds, and if you're skilled and you ask the right questions, what you're looking for. But then you also need to manage the schedule. What about if the caregiver is sick and she's taking vacation and she can't be here? So you probably need to find a replacement, or the family members need to come in, for the respite services for the caregiver. And so instead, the agencies, they would provide you some backup options, right? For the full service agencies, you always get someone qualified, equally qualified, and equally protected on your property. And for the registry agencies, you get someone, and then you become the employer again, right, for another 1099 employee of yours. And so that's the three sources of getting the caregivers, But the good thing about them is there are no requirements. There's no limit about how many hours you want the caregiver to provide to you or your loved ones with regard to services. And by the way, for Medi-Cal services, if you qualify for Medi-Cal or if your loved ones qualify for Medi-Cal, and the weekly service limit is normally 25 to 40 hours of care, and it's based on the assessed needs, right? There's assessment for Medi-Cal. There's going to be a case manager coming into your home to do the assessment on a periodic basis, and the include how many activities of daily living the client would need to be qualified for the services, and the length of the services, how many hours. And the Medi-Cal benefit does not cover overnight services. Your hours are most likely 5 to 8, no more than 8 per day. And there are no overnight care in that case. And the reevaluation by a case manager is every 6 months. For the agencies who are private hire, of course, you could do hourly service, and you could do overnight service, you could do live-in services, and that's just based on your needs and your agreement with the agencies or your private hire. So that's the difference, the major difference I want to talk about between Medicare and Medicaid and service agencies, right, in that case. And so when it comes to, for the private duty agencies, say my agency, right, we don't deal with Medicaid services, and we don't deal with Medicare reimbursement. So for us, it's private duty. Agencies like us are called private duty non-medical home care services. And there are a few ways to pay for that service. And I have a handout there. If you guys don't have it, you can look for it. And I want to talk about long-term care insurance a little bit. And I'm talking about it from a perspective that how you get reimbursement when you work with the agencies, assuming that you already have it, right? And so what we do is the policies, from what I have seen, are very different. And some of the policies, they have lifetime benefit. And some of the policies, they don't. And it's also limited with regard to how much money you get for reimbursement. And if there's a lockup period, you have to wait. And what is a waiting period before the benefit kicks in? So it all depends on who has issued the policy and what time the policy was in place. And so it really depends. But there's definitely a requirement of how many ADLs there are when it comes to the client's needs to get reimbursed, right? It could be up to half of the reimbursement, and there's a daily limit of the benefit, and there's sometimes there's weekly, monthly, it just varies. What we do is we provide the shift notes, and agencies, and by the way, as far as I know, for the reimbursement, for the clients to get reimbursement, and a lot of policies I have dealt with through my agency, and they're required to have a full service agency to provide that. And it can't be private hire. So we provide the invoice, and we provide the shift log to the long-term care insurance companies. They look at that, okay, what was done today? Meal prep, transportation, bathing, vital signs and stuff like that. And then they provide the reimbursement. And sometimes they call us, the case managers from the long-term care insurance agencies, they call us and say what exactly was done, right? How many hours was done? And they also set up a limit. Would that be 8 hours, 9 hours? It really depends. And we say, well, the client really couldn't do this, and there are 5 ADLs, and we had to cover. And from 8 o'clock in the morning until 9 p.m., the client goes to bed, right? And then they talk to us, and they decide on the benefit they would give to the client. So that's long-term care insurance. It covers a lot of that, which is really beneficial. I'm not sure if there's any veterans in today's group, but that's another benefit we deal with. And we provide similar documents, the invoice, and also the shift log to the veterans organization for them to get reimbursement. And it's also quite complicated to get the benefit from the veterans services. And you have to meet certain income levels, be that your Social Security benefit and everything kicks in, and you calculate your expenses based on what you spend or estimate on home care services. And it gets deducted, and they set a new limit, and they calculate based on that. The same applies to the surviving spouse of the veterans. So that's another way. And asset conversions, of course, you could always take out a line of credit or reverse mortgage and ways like that to pay for the services. And Medicaid programs already talked about, so I'm not going to get into that. And there are also tax credits and cost of care reductions, and it's based on the programs offered by the state. It really varies. You could look into that, especially if the client has Alzheimer's or dementia, and there are programs to support the families with the care cost, and it depends. So to wrap it up, most of the non-medical home care services in the long run are not supported by the government-funded programs. And so private sources are the main source of the payment. Yeah. Thank you.